Welcome to the Deep Dive. Today you've set us a real challenge, the statute of frauds. Sounds simple, right? Certain contracts need to be in writing.
Like deals that take over a year?
Exactly. But what happens when it's not one neat document? When you've got notes, maybe emails, a memo, some signed, some not. How do you piece that together?
That's the real puzzle. It's where the statute of frauds gets tricky. So our goal today is to really unpack the modern rule for this, the Crabtree v. Elizabeth Arden standard. It lets you connect those separate pieces.
Okay.
And we'll model how courts do it, looking element by element, just like they did in the case.
Great. So before we get into piecing things together, let's just confirm, what kind of agreement are we dealing with here that even needs a writing and a signature in the first place?
Yeah, good starting point. The contract here was for 2 years of employment. That's a classic example of a contract not to be performed within a year.
Right, over the 365 days.
Exactly. So the statute of frauds kicks in. It demands a memorandum, basically, a written record of the key terms. And crucially, it needs to be signed or subscribed by the person you're trying to sue. That's the party to be charged.
Subscribed?
What?
That just means signed to show you meant to authenticate the info, yeah. Not necessarily the whole contract itself.
That's generally right, yes. It's about authenticating what's written down.
Yeah.
So the big question then becomes, if those essential terms like how long the job lasts, the pay, who's involved, are spread across different bits of paper.
Like an offer letter here, an internal note there.
Can you legally stitch those together to make one valid memorandum?
And the answer is?
Yes, you usually can, thanks to the approach really cemented in the Crabtree case. Courts get that business isn't always neat and tidy.
Right.
So the modern rule lets you read signed and unsigned writings together. But there are conditions. 3 key ones, really.
Okay, what are they?
First, you absolutely need at least one document that's signed by the party you're suing. Think of it as your anchor.
The signed anchor, okay.
Second, that signed document needs to show there's some kind of contractual relationship going on between the parties.
Doesn't have to be the full contract, just evidence of a contract?
Exactly. And third, the unsigned papers have to clearly relate to the same thing, the same subject matter or transaction as the signed one.
Okay, that third one sounds like where things could get fuzzy. If the signed paper is kind of vague, how do you prove it connects to the unsigned one that maybe has the missing salary or duration? Can you bring in outside proof? Parole evidence.
You've hit the critical point, and that's what Crabtree tackled head on. Yes, parole evidence is allowed, and this is a huge but, only for a very specific job.
Which is?
To connect the documents, to show they relate to the same deal and that the party you're suing actually agreed to what's in the unsigned paper. You absolutely cannot use parole evidence to fill in the missing terms themselves.
Okay. So, outside evidence can build the bridge between the papers, but the actual terms of the deal have to be in those papers once they're connected.
Precisely. The full deal needs to be within the 4 corners of the combined documents.
Got it. Let's make this concrete. Let's dive into the case that really set this standard. Crabtree v. Elizabeth Arden Sales Corp. Can you walk us through the story? First, what are the legally dispositive facts? What facts really mattered here?
Sure. So Nate Crabtree was negotiating for a job with Elizabeth Arden. He was leaving a secure position, so he specifically wanted a 2-year contract for security.
Okay.
They agreed on a pretty unique salary setup. $20,000 to start, then it jumped to $25,000 after 6 months, and finally $30,000 after the first year. Very specific tiers.
That does sound quite specific. And the paper trail wasn't clean.
Not at all. There were 3 key pieces of paper involved. First, an unsigned internal memo. It was written by Miss Arden's secretary, and it detailed that whole salary structure and included a note. 2 years to make good.
The duration.
Exactly. Second, there was a payroll change card, but this one was signed, initialed by the general manager, Mr. Johns. It detailed the first salary increase.
Okay, signed document number 1.
Right. And third, another payroll change card, this one signed by the comptroller, Mr. Karstens. It requested the final salary increase and added a note per contractual arrangements with Miss Arden.
Signed document number 2.
Okay.
So a mix of signed and unsigned with different bits of info. And what was the core legal issue the court had to decide?
The precise legal question was, could these 3 different documents where only 2 were signed, and neither of those explicitly mentioned the 2-year term, be read together as one package deal to satisfy the statute of frauds writing requirement?
Makes sense. What rule of law did the court apply to figure this out? Can you state the rule and break down its elements for us?
Yeah, they applied what we call the modern piecing together doctrine. To bring an unsigned paper into the fold, you have to satisfy a 3-part test.
Okay, what's the test?
Element 1. Signed writing intent. The signed documents need to be signed with the intention of authenticating the information in them. Element 2. Refer to same transaction. All the documents, signed and unsigned, have to clearly refer to the same deal or subject. Element 3. Assent to unsigned. You need proof, and here, parole evidence can help, showing the party being sued actually agreed to the stuff in the unsigned document.
Perfect. Thank you. Now for the court's elemental analysis. Let's go step by step. How did the court apply that first element, the signed writing intent? The managers signed payroll cards, not necessarily thinking, I'm signing a contract.
Right. But the court said that didn't matter. The rule isn't that you have to intend to sign the contract. You just have to intend to authenticate the information in the document you are signing.
Oh, okay.
So since these were official payroll change cards, signed or initialed by company managers like the general manager and comptroller in their official roles, the court found they clearly intended to authenticate the payroll information. Element 1. Check.
Understood. Okay. Element 2 feels trickier. Refer to same transaction. How did they link that unsigned secretary's memo to the signed payroll cards without just relying on someone's testimony saying, oh yeah, they're related?
They looked inside the documents themselves. This is key. The court compared them and found really strong internal connections.
Like what?
All 3 documents mentioned the same parties, Crabtree and Arden. They all mentioned his job title. And critically, they all contained that very specific, identical 3-tiered salary, $20, then $25K, then $30K.
The unique fingerprint of the deal.
Exactly. The court basically said it was hardly possible this super specific salary structure could refer to anything but the same employment agreement. The documents linked themselves through this internal consistency. Element 2. Check.
Okay, that makes sense.
Yeah.
So how did they handle the third element, showing assent to unsigned? Specifically, proving Arden assented to that unsigned memo with the crucial 2 years to make good phrase.
Right. This is where parole evidence was allowed, but notice its limited role. The court looked at outside evidence testimony, the circumstances not to supply the 2-year term, but to show Arden accepted the memo containing it.
And what did that evidence show?
It showed a few things. 1, the memo was written by Arden's own agent, her secretary, during the actual negotiations. 2, the company's later actions lined up with the memo they paid the first salary increase as scheduled. And 3, that note on the second signed payroll card by the comptroller saying the raise was per contractual arrangements with Miss Arden strongly suggested the company recognized a binding deal based on those earlier terms, which included the memo. Element 3.
Check. The actions backed up the memo's content. Okay, but there's still that phrase, 2 years to make good. Duration is essential for the statute of frauds. How did the court get from that slightly ambiguous phrase to a definite 2-year term?
Good question. Here, the court allowed parole evidence again, but for a different purpose. Not connecting documents, not showing assent, but interpreting an ambiguous term that was already present in the writings.
So explaining what 2 years to make good actually meant in context.
Precisely. They said, look, without context, maybe it's at-will employment. But given Crabtree pushed for security, the negotiation history, and those structured raises spanning 18 months already, the most reasonable interpretation of 2 years to make good was a definite fixed term of 2 years.
So they use context to clarify, not invent the term.
Exactly. Clarify the essential term of duration, making the whole package of documents sufficient.
Okay, so they ticked all the boxes, signed anchor, connection, assent, and all essential terms present or clarified.
After analyzing all the elements, what was the court's final conclusion? The New York Court of Appeals upheld the lower court's decision for Crabtree. They held that, yes, these 3 separate papers, when read together, and using parole evidence only to connect them and explain that one ambiguity, formed a sufficient signed memorandum to satisfy the statute of frauds. The 2-year contract was enforceable.
That's a really clear breakdown. It shows how the documents need that internal glue. Let's test this connection idea with maybe a slightly weirder hypothetical.
Okay, let's hear it.
Imagine you're selling something unique, say a possibly cursed Civil War-era antique doll. Spooky.
Rare.
Price is $5,000, so it needs to be in writing under the UCC statute of frauds.
Okay, creepy doll, $5,000, writing required. Got it.
The buyer gives you a check for exactly $5,000, signed by the buyer. That's your signed writing, your anchor.
Yep, a signed check works as a signed writing.
Later, you, the seller, send unsigned text. Deal for the doll is done. Pick up next Tuesday. Now, if that check just says $5,000 and doesn't mention the doll or the text, can you connect them using the Crabtree logic to satisfy the statute?
Ooh, that's a good test. And I think the answer is likely no, that probably fails.
Why? The amount matches.
It fails the referred to same transaction element based on internal evidence. A check for $5,000 could be for absolutely anything, right? Rent, maybe repaying a loan, buying groceries for a year.
Huh. Maybe not groceries, but okay, point taken. It's generic.
Exactly. Unlike the Crabtree case with its unique tiered salary that pointed strongly to one specific deal, a simple check amount doesn't inherently link to that specific text message about a cursed doll.
But what if I testify? Can I bring in parole evidence to say, Your Honor, that check was definitely for the doll. I sent the text right after.
And that's precisely what Crabtree says you can't do with parole evidence. You're trying to use testimony to create the link between the subject matter of the check and the text. The link needs to be suggested by the documents themselves.
So if the check maybe had doll payment in the memo line, or perhaps the date matched the text reference,
then you might have an argument. Then there's some internal reference, some clue on the face of the documents pointing to each other. But without that internal hook, using parole evidence to supply the entire connection is just too risky. It opens the door too wide to potential fraud, which is what the statute is trying to prevent.
Got it. Parole evidence is the helper, not the hero. It connects things that already look related. It doesn't create the relationship from scratch.
That's a great way to put it. It reinforces the connection, shows assent, clarifies ambiguity, but the core terms and the basic link must be findable within the writings themselves.
Okay, this has been incredibly helpful. Can we synthesize this into maybe a checklist? Something someone listening could use if they face a jumble of documents for a contract.
Absolutely. Thinking about it like an exam approach or even just analyzing a real-world situation, here's a logical sequence, a kind of diagnostic tool.
Okay.
Step 1, trigger test. First, ask, does this contract even fall under the statute of frauds? Is it for land over 1 year, sale of goods over a certain amount, etc.? If not, you stop here, no writing needed.
Right, don't analyze if you don't have to.
Step 2, signed anchor. Find all the relevant pieces of paper or electronic records. Do you have at least one that's signed or authenticated by the party you want to enforce the contract against? If no signed anchor, you're probably out of luck.
Anchor secured. What's next?
Step 3, essential terms, check. Look at your signed anchor. What essential terms are missing? Do you have the parties, the subject matter, the price, the duration, if applicable? Identify the gaps.
Find the holes.
Step 4, the connection test. Crabtree rule. Now, look at the unsigned documents. Do they seem, just by looking at them, to relate to the same transaction as the signed one? Is there internal consistency, like names, dates, unique details? Remember, parole evidence here only shows the link exists and the party assented. It can't supply the terms or the link itself.
Check for internal consistency. Use parole evidence carefully.
Step 5, ambiguity clarification. If you do find an essential term within the connected documents, but it's vague, like reasonable time or 2 years to make good, now parole evidence is allowed to explain what that term meant in the context of the deal.
Clarify existing terms, don't add new ones.
And finally, step 6, synthesis. Put it all together. If, after connecting the documents, using parole evidence only for connection assent, and clarifying any ambiguities using parole evidence for context, you can find all the essential terms spread across those writings, then the statute of frauds is satisfied. The contract is validly memorialized.
That's a fantastic framework. It really demystifies the process. It shows that the law isn't just about rigid formalities, it's trying to find reliable evidence of a real agreement, even if the paperwork isn't perfect.
Exactly, and it reflects a conscious policy choice. The Crabtree court actually said something really interesting about this.
Oh. What was that?
They basically acknowledged that this more liberal approach might slightly increase the risk of someone occasionally succeeding on a fraudulent claim, but they argued that risk was worth taking. Why? Because the alternative, sticking to a super rigid rule where any unsigned document is ignored, even if clearly related, would mean denying enforcement to far too many genuine agreements just because of a paperwork technicality. They felt it was better to risk occasional fraud than to guarantee frequent injustice.
That's a powerful point.
Yeah.
It leaves us, and you listening, with something to think about, doesn't it?
It really does. It forces you to consider, in the balance between preventing fraud and enforcing actual agreements, how much potential risk are you willing to tolerate to achieve fairness? Where do you draw that line?